invite you the best lecturers to the best speakers around the globe that you have value addition today. I feel honored to welcome our esteemed speaker for the session, Ms. Krifi Agrawal. Ma'am is a young, strategic, and responsive academician who is an expert in the legal field, having more than 4 years of experience in teaching and research. She completed her BA LLB honors from BPSMB Haryana and also holds a master's in criminal and security law. She specializes in laws related to cybercrime, juvenile delinquency, criminal justice administration, domestic violence, family, drafting, and vetting of documents. Ma'am has publications in reputed national and international journals. She has been invited as speaker and conducted many webinars and orientation programs in collaboration with many institutions of repute. She is working as an assistant professor at Indraprasth University, Delhi. Adding to her credit, she has just many national moot court competitions organized by prestigious universities across the India. Thank you so much, ma'am, for joining us, and thank you everyone for joining us today. And without any further ado, let us begin. I would like to request the speaker to take the session forward and enlighten us all. You can ask your questions by the chat box.
Thank you so much, Priyanshu. A very good evening, everyone. As you all know, the topic of today is mediation analysis, issues, and recommendations. So, before starting, let me start with the story. Everyone knows the story. Why mediation? You all know that we as a human being, we all as a human beings know, have come a long way in the evolution. You all know we are growing so fast, evolving so fast, the process is evolving so fast. And as time is lapsing, our nature, as time is lapsing, our needs, our way of life, is becoming more complex. I hope you all agree with this point, that with the passage of time, our needs, our way of living, these all are getting complex day by day. So to deal with such complexities, and while we were having these complexities, we have more disputes. You all agree, we have more disputes, and to resolve these disputes, you cannot like always run down to the courts. You need to like get an option, and mediation is one of the option. Why mediation is one of the option? Because however, for every petty clashes of interest between people must be having like clashes of interest, so you cannot even go running down to the courts. So for this, mediation is very useful. This is the topic of today's, what is mediation. You all know that mediation is basically a process, is a method in alternative dispute resolution which is available to the parties. You all know it is available to the parties, and it is mentioned under ADR, that is alternative dispute resolution. Now, what is mediation, students? Let me tell you what is mediation. Mediation is, we can say mediation is essentially a negotiation which is facilitated by a neutral third party. See, mark my words, what I'm trying to tell you is, which is facilitated by a neutral third party. I'm talking about neutral third party which is not biased even. So in mediation, there are two parties which will be like guided by, and the problem will resolved by whom? By a neutral third party. This is what mediation is, students. Now the question is, who attends mediation? This is a very important question. Like, rather, before moving to the point, who attends mediation, I would like to tell you why mediation. I would like to tell you why mediation. Why mediation? Because to reduce the misunderstandings, to have a clarifying priorities, and to explore areas of compromise by generating options, like we can resolve a dispute of our own by helping with the help of third neutral party. That is why mediation is necessary. Now the major question is, who attends mediation? Obviously we all know the parties, they attend mediation. All the all the concerned parties attend mediation process. Now the question is whether their advocates, can attend mediation. So it is totally on the parties. If the parties want, that they may like answer the questions, or they may question something. So the lawyers of the parties may attend mediation. This is one of the point, and it is totally on the demand and desire. It is totally on the demand and desire of the parties. If they feel like, they can call their lawyers in the mediation as well. Now the question is, who decides this mediation? Who decides? And before that, I would like to tell you that people tend to ask me this question, when I talk about mediation, that how much time generally it takes. So it totally depends on the issues, it totally depends on the parties. Sometimes it will take 4 to 8 hours to decide a dispute, and it totally depends on the nature of the issue. What issue is there, what issue is not there. What I can generally tell is, uh, minimum average time is 3 hours. 3 hours is the minimum time, which is definitely parties take, which definitely parties take to solve the dispute. Now the question is, students, who decides mediation? When a dispute come to a mediation, when you have a common ground of dispute, it reach by the both the parties. Now the question is, court will not interfere. First of all, listen to me this point. Court will not interfere when the matter reaches the mediation cell. Court will never interfere. As I already told you, that a neutral third party, he or she will resolve that dispute. Now the question is, who will going to appoint that mediator? It is totally the discretion of the parties. They will find the one suitable person who must be knowing about the common grounds of the dispute. And if if that common person know about the dispute, he or she may resolve the dispute. But mark my words, court will not at all interfere in the mediation center. It is the discretion of the parties. They can appoint any person to resolve their disputes. They may choose their own mediator. And after they choose their mediator, they feel it is their option to conduct and to schedule a mediation session for them. Now the other question is, generally, which came in our mind when we talk about mediation, what about the confidentiality? How much secrecy will be maintained? See, students, mediation is a process. As I'm telling you, mediation is a process. Means you are going to appoint your own mediator, a neutral party you are going to appoint, and it is totally up to you. When it is the choice of the parties that you are going to appoint your own mediator who know about the common grounds of your dispute, then it is your choice. If you feel like that it will be made public to the parties, it will made public to other people, like your disputes, your grounds of dispute, then it will become public. What do you do if there is breach of confidentiality? Okay, fine, I read a question. What you do, see, that is totally discretion of the parties, whether they want to have to maintain the confidentiality or not. If you feel like, see, suppose you are the two parties and the third mediator you choose of your own, then how you will breach that point? There is no point of breaching that. When you decide that you don't want to get these points public, then there is no harm in it. If you feel like disclosing it, then there will be breach, no? And if you allow someone to disclose these facts, it will not be a breach. So this is how it goes. Now the question is, the most important question is, hardly matters you had an agreement that your dispute will reach the mediation cell. Hardly matters you are having agreement or not. What matters is, students, that you understand one point, that it is always not possible. To it is not always possible to reach a common ground. It is not always possible to reach a common ground. Now suppose if by mediation process you are not satisfied, you does not come to a conclusion, and that mediator does not is not successful in solving your issues, your disputes, then it is totally your call. You may again follow that traditional trial method which you tend to follow at the time of the court. You can go to the court. It is not like that once your matter reaches the mediation cell, you cannot go to this court. You can, after mediation also, you can opt this traditional trial method also. So what the point is, what I feel is, the mediation process, the mediation process, makes the litigation process, I feel this, more smoother. And then the trial will take less time, the court will take less time during the trial, because ultimately at the time of the mediation, when you are sitting with your opposite party, you have a common ground of dispute, though that mediation process was not helpful for you, you does not come to a conclusion. But this what I feel, that after having a mediation process, that becomes very useful. Your litigation process will become smoother after the mediation process. This is the point. Now the question is, how many types of mediation do we have? So students, we have two types of mediations, and one is civil mediation and the other one is private mediation. Now the question arises, what do you mean by civil mediation? See students, civil mediation means, you have a cases of civil nature. Civil cases means, uh, in the cases where generally people sue for compensation due to injuries. You all know that in India, CPC and Arbitration and Conciliation Act deals with these civil cases. So, and I would also reflect one point in this regard, that you all must be knowing, there is section 889 of the Code of Civil Procedure Code 1908, which talks about mediation. Though it talks about 4 points, it talks about arbitration, conciliation, judicial settlement, through Lok Adalat, and the last point is mediation. So you all please note this point, that we have two types of mediation, civil mediation and the private mediation. And when we talk about section 89 of the Civil Procedure Code 89, the D point talks about mediation. In mediation, we are talking about all these things. Now the other question is, what do you mean by private mediation? And before coming to the private mediation, I would like to draw your attention towards a very very important amendment, rather I should say very important law. And what the important law is, see, you must be having one question, no ma'am, just tell me कि mediation जो होता है वो पहले भी हो सकता है, मतलब कोर्ट में एप्लीकेशन लगाने से पहले भी कर सकते हैं, नहीं कर सकते हैं? तो स्टूडेंट्स, आई वुड लाइक टू ड्रॉ योर अटेंशन टुवर्ड्स वन वेरी सीरियस पॉइंट, एंड व्हाट द पॉइंट इज, नाउ वी आर हैविंग Commercial Courts Act 2015. Commercial Courts Act 2015 was enacted, and where in section 12A, if you all are having Commercial Courts Act 2015 with you, kindly note this point, that section 12A of Commercial Courts Act 2015 talks about this point, that first of all, write down one act. It is very useful for you people. The act is Commercial Courts Pre-Institution Mediation and Settlement Rules 2018. In short form, you can write down PIMS rule. PIMS rule, PIMS PIMS rule. And it was framed by the government under the act. What this act was saying, that if there is any matter, if there is any commercial dispute, then before filing a suit, you all must have, I will be answering all these questions in the last, please. First of all, I would like to continue with this point, that the commercial courts, I was talking about the Commercial Courts Pre-Institution Mediation and Settlement Rules. In short form, we can say PIMS rule. What happens, what this rule is saying, before instituting a civil suit, it is mandatory for everyone, because in section 12A it was written shall. So it is mandatory for the parties that before instituting a suit, you all must have to, you all must have to do pre-institution mediation and settlement. Before coming to the court of law, you all have to do pre-institution mediation, which is very important point. I hope you it is very a good point for you people. You must not be knowing that. And section 12A of the Commercial Court Act is talking talking about the same thing. Section 12A of the Commercial Courts Act says that, 3 months, within 3 months you have to solve that matter. Within 3 months you have to solve that matter, and with the consent of the parties, 2 more months can be given with the consent of the parties. It is talking about this point. Now the question is, what is private mediation? See, private mediation is something where, court have not said anything to you. You are privately mediating yourself. I am giving you one, very, very like example. If you all look at the Indian villages, all must be knowing about Indian villages. You all must be knowing about, since the ancient times, in the informal way, we are solving disputes through mediation. Why through informal way? Because, traditionally in the villages, now also, and today also, the elder man used to sit in the village, play the role of the, mediator, and help the parties to reach to a conclusion. They, help the parties to, resolve their disputes. So ultimately, this alternative dispute resolution, if we talk about Indian villages, this is called private mediation, is followed in informal way from the very, ancient times. So if we talk about, see, hope you all understand, we are having panchayati system. So we cannot say this thing, no, ki this is the modern concept. This is a very, like old concept, which is which we tend to follow in the, ancient times also. In many Indian villages today also, we use this process. Now we call this process mediation in the urban areas. You all must agree with me, because in the Indian villages, in many of the villages, people, tend to have panchayats. The head of the panchayat, that old man, used to solve the dispute of the people. People nominate one elder man or a group of individuals who solve the dispute of the parties, who tend to act as a mediator and resolve the disputes pertaining to that particular village. I'm not talking about other villages. Pertaining to that particular village, people tend to follow that process. Okay, moving to the next point, I would like to highlight on very important case law. You all must be knowing that case law. And what is the case is, the case is Infrastructure Limited, FCONS Infrastructure Limited. If you feel like writing, you can write down FCONS Infrastructure Limited versus Cherian Verke Construction Company Limited. You all must be knowing that case. And what was held in this case, that it was held in this case that all the cases, regarding the trade, commerce, contracts, consumer disputes, we can solve all these cases through mediation. We can solve all these cases through mediation. Even I would like to highlight one more point. Is that even, cases pertaining to, tortious liabilities also may fall under this point. Surinder sir, I'm extremely sorry. I cannot show it through a slides, but I feel like having it, I'll be sharing it with you. And I would like to answer one question as well. I just saw one question. Someone was asking that, about that court annexed villa. Court annexed question. I would like to highlight that question, that, we can say that, civil mediation is somewhat, similar to court annexed. Yes, I'm repeating the case law. Give me 1 minute. I am highlighting to one question. Someone asked me that, can we say that it is similar to court annexed? Yes, we can say that it is related to court annexed. to, civil mediation is somewhat similar to court annexed. Why? Because, in case of court annexed mediation, there, are advantages, that, there is surveillance of court. So we can say that it is court annexed. And, specifically, I would like to mention one more point, that Order 10, Rule 1A of the CPC talks about this. And what it talks about that, court has sent the matter for alternative dispute resolution, and mediation is one of them. According to my view, this is what my view. Someone asked me that whether civil mediation is court annexed. So on this point, I would like to answer this question, that I feel so, that somewhere it is court annexed. Why? Because, there is surveillance of the court, and in, Order 10, Rule 1A, it is, court has to send the matter to the alternative dispute resolution, and mediation is one of them. So that is why I feel so it is, civil mediation is somewhere court annexed. So and what I feel is, according to my point of view, court annexed mediation should be preferred. What I feel is, when I'm talking about civil mediation and private mediation, what I feel is that court annexed mediation should be preferred. And someone is asking me, ma'am, can you please repeat the case law? Yes, I'm repeating the case law. I'm repeating the case law. You may please write down the case law. That, what I would like to reflect on the point is that not just the cases pertaining to personal issues, but according to the landmark judgment, that is FCONS. I would rather dictate the spelling, FCONS, AFCONS, FCONS, Infrastructure Limited, versus Chere and Varke. I'm dictating the spelling, CHEREAN Varke, VARKEY, Varke, construction company, private limited. And what this case is telling us, that, not only cases pertaining to, personal issues, it is saying that all the cases rather related to, trade, commerce, contracts, consumer disputes, anything can be mediated easily. Are you all getting it? There is something in our minds. Okay. So even in this case, it was held that, cases pertaining to tortious liability also can go in the mediation. I hope you all have wrote this case. And another question a student is asking is that, why rather than personal like issues, also these cases fall under, we can have the mediation. Why? What I feel is that, court cannot totally focus on the each and every case. And what mediator can do, mediator can individually focus on every single issue. Mediator can focus on every single issue. So what I feel is that, mediation is a good opportunity for the people, for the parties, they can opt for. I would also like to reflect on one case law, and that is Dayavati versus Yogesh Kumar. I would also like to reflect on one case law, Dayavati versus Yogesh Kumar. Students, in this, Surendra sir, you are asking about the year of the. Could you please type it, ma'am? I'm dictating it, don't worry. Sir, you were asking about FCON's year. It is 2010, sir, 2010. And one is talking about, like, ma'am, can you please type? I'm dictating it. And the case is Dayavati versus Yogesh Kumar. Dayavati versus Yogesh Kumar. Dayawati. Dayavati versus Yogesh Kumar. Okay, sir. What happened in this case is, a question as to criminal cases. A question as to criminal cases being referred to the mediation was raised. A question was raised. We were talking about Afcon's case that, trade cases, commerce cases, all these cases can be referred to the mediation. Now, in this case, the question arose that whether criminal cases can be, in mediation can be raised or not. So it was observed in this case, that in criminal courts may refer the case to mediation. It is the discretion of the criminal courts. If they feel so, they can refer those case to the mediation. So never restrict to this point that only personal issues, only trade cases, consumer disputes can only send to the mediation. If criminal courts feel so, they can refer those cases to the mediation. However, they cannot rely to such settlements made by mediating. This is what we were talking about, civil mediation also, that if you are not satisfied with the conclusion, if you are not satisfied with the, like you are you don't come to a conclusion, it is totally your call. You may opt traditional trial method. So this is what this case was telling us, that it is the discretion of the criminal courts. If you feel so, you may send criminal matters to the mediation if you feel so. And if you don't agree with this mediation, if your matter does not have a settlement, then it is your call. You can adopt the traditional method also. So what I feel is that criminal matters should not be sent to mediation. Why I feel so? In this case, this concern was raised, but according to my interpretation, what I feel is criminal matters should never be sent to mediation cell. Why? Because as far as criminal case is concerned, a punishment is to be served. And we all know that mediation cell or ADR cell cannot do such things. This is what we all know. So this is my personal view. As far as this case is concerned, a question was raised regarding criminal case, but what I feel is that one should not send the criminal case to the mediation, because somehow, thank you so much, Surinder sir, thank you so much. Somewhere somehow punishment is to be served, and so that is why mediation cell or ADR cell cannot serve that punishment, cannot solve that point. So that is why that cannot be sent to the mediation cell. And one more thing I would like to tell you, another case, that is K Srinivas Rao. I would like to highlight on one more case, that is K Srinivas Rao versus DA Deepa. Hope you all have wrote the case. It is the case of K Srinivas Rao versus DA Deepa. What happens in this case is that the offense of section 498A is non-compoundable. We all know this fact, that under IPC section 498A, the offense is non-compoundable. In this case, what happened is that court allowed the parties to explore the option of ADR. The court allowed the parties to explore the area of mediation, and it was specified in this ruling that if criminal courts there exist element of settlement, parties may explore the point. If they feel like in this particular case it is offense of non-compoundable offense, it is non-compoundable offense. But if party feels like they come to a conclusion through they had settlement through mediation, they can do so. This is all I would like to yeah, okay, I was reading one comment. So this is, I would like to highlight through the cases about appropriate cases through the mediation. And what I would like to tell you is that all cases might not be open to the option of mediation. I hope you all agree that all cases might not be open to the mediation, depending on what happens is depending on the gravity of the offense, and depending upon the understanding of the court, it is the discretion of the court, it is the discretion of the party, you can opt for mediation. This is all I would like to talk about mediation. Feel free to ask questions. I would like to invite Dr. Ashu, if you. And one more thing I would like to tell you, I hope, I guess you all must have wrote that point. I already mentioned, in my lecture, that now Commercial Courts Act, made it mandatory that you all must be, before filing, civil suit, before filing your civil suit, you all must be, what you all have to do, you all have to do a pre-institution mediation settlement before, coming to a court. Before coming to a court, what you all have to do, you all have to go through with the pre-institution mediation and settlement. You all have to follow that. I would like to highlight the section number also. Section number 12A of the Commercial Courts Act 2015 is making it mandatory that when one person is filing application within 3 months, you have to complete that mediation, and with the consent of the parties, you can extend the period up to 2 months more. So we can say that court is moving to that area. We are more following this alternative dispute resolution. And one more thing I would like to highlight on, one more thing. Pre-mediation is a failure under Commercial Courts Act. I don't think so. Pre-mediation is a failure under Commercial Courts Act. I don't think so. It is a failure. Ultimately, they are saying just go with the flow. Go with the flow. Just before instituting a civil suit, go through a pre-institution mediation and settlement. If you are not satisfied with if you are not happy with the decision, you can absolutely approach the court of law. You can file a civil suit. So I don't think so. It is a failure. And what I feel is that it is the intent of the legislation. This is what I want to tell you, that it is the intent of the legislation that to decrease the burden of the court, one should follow this mediation process. Because as in the starting speech I have, in the lecture I have told you, people know that for every clash of interest, for every clash of disputes, one cannot run down to the courts. One cannot run down to the merely running down to the courts. So we have to follow this, and this is what I feel is that it is the intent of the legislature to decrease the burden of the court, that one should follow the mediation process. And for every petty clash of interest between the people, you cannot even run down to the court of law. It is very complicated. How do people find mediators? See, it is there a list of public approved mediators? See, for them, there are mediators, but as I told you that people choose their neutral third party. That is their discretion. It is the discretion of the parties. They choose their mediators. And yes, there are list of government approved mediators as well. As you all know, I am presuming that you all are from the law school. You all must know about the paralegal volunteers. There are paralegal volunteers. There are ADR cells, alternative dispute resolution cells. There are mediation cells. Somewhere, some judges, sit as a mediator. Some good advocates, experienced advocates sit as a mediator. So they are. Any questions? Thank you so much.
I hope that our participants have no more questions.
Because I was reading those questions, I was answering those questions in the That's
Ma'am,
right.
we have got one more question, like how much does a mediator cost, or are they paid by state?
It depends. Somewhere, somehow, oh, I'm so glad you want to listen me again. That is, very good thing for me. No, it is the party who pay. It is the party who pay to the mediator who has to bear the who has to bear the cost of the mediator. Any questions? Okay, Garima is saying that recording of the session is available on the YouTube. So all who want to listen again can refer to the YouTube link and can listen to that. Please share the link. Garima, I would like to do one favor. Please, can you please share that YouTube link in the chat box, please? And I would also like to refer one thing that, the Commercial Courts Act fees was given in the Commercial Courts Act for pre-mediation. You can refer to that fees also. Sure, sir. I would like to come once again also. Thank you so much. Thank you so much.
Thank you so much for everyone for your lovely questions, and thank you so much, ma'am, for this vibrant, interactive, and knowledgeable session. I would also like to thank all the participants for joining us today, and I would request everyone to please fill up the feedback form in order before you leave to receive your certificates too. And thank you everyone for joining us. One more announcement that I need to make here is like Mediate Guru is proudly collaborating with the Newcastle University in United Kingdom in our upcoming virtual international negotiation competition 2022. So registrations are open now. Don't miss this opportunity. You must participate in this competition to compete with global teams and get the experience of practicing and learning in the field of ADR. So if you don't want to miss any updates from Mediate Guru, follow us on these social media handles and also join the WhatsApp updates groups and in the chat box. Stay healthy, stay safe. See you
Thank you
soon.
so much,
Thank you.
everyone. Feedback form is available in the chat box. Kindly fill it. Thank
Yeah.
you so much, Mediate Guru.
Okay.